Hi, I am CA Pritish, and in today's video we are going to discuss a problem which India is facing, or rather our judiciary in particular is facing, to settle the court cases when it comes to solving the property issues when a will is not written. So in this video we are going to discuss everything about a will, how simple it is to write a will, and what are the legal aspects of writing a will. So stay tuned till the end of this video so that your legal hairs do not face any problem after your death. In simple terms, a will is the legal declaration of the intention of the testator, that is one who writes the will, in respect of the property which has to come into effect after his death. So it is very important to note that after the death of a person, a property that he owns will devolve or go into his legal heirs in two ways. That is, first one is if a will is written as per his will. But if a will is not written, then as per the law of succession. So in case of Hindus, it will go as per the Hindu Succession Act, and in case of Muslims, it is Mohamedan Law, and in case of Christians, it is Indian Succession Act of 1925. So it is very important to write a will so that it will go to the person whom you desire and not as per the law. So everything might look good now, but the problem is that once after your death, the issues will keep starting. So in case to avoid that and your family is very intact, it is your responsibility to write a will when you are alive. And writing a will doesn't cost much, and it is a very simple process. You need not break your head. So let us get into the process of writing a will. Now everybody has this simple question: how to write a will? Whether we need to consult a lawyer to write a will? So the answer to this is a simple no, because all that you need to do to write a will is take a piece of paper and write your intention, that after your death to whom the property will go to. So there is no legal format as such to write a will. So it can also be typewritten, but the most important thing that you need to know is that you should not be of unsound mind. That you should be of sound mind, and you should have attained the age of majority. And also you need to put your signature at the bottom or your thumb impression. And also it should be attested by 2 witnesses. A will can be made at any time during the life of the person. But the most important thing that you need to know is that it can be changed n number of times before his death. So there is absolutely no problem, but the only condition is that only the last will that you have made will be enforceable and not the wills made earlier. What are the properties that are covered by will? So in that case, properties, whether movable or immovable properties, can be covered by will. But the only thing is that the property should be owned by that person, that he should have absolute right over that person. So in case of an ancestral property, in case of Hindus, it cannot be given through a will. Only self-acquired properties only can be given in that case. Whereas in case of Muslims or Christians, that problem is not there, because the concept of ancestral property does not exist in these 2 laws. The fundamental rule is that one can pass only what he has. In case if he does not have the rights, or the rights are non-existent at the time of making the will, then it is not possible to write a will in respect of that property, or in respect of that share which has not already got. So it is very important the right should be existent in respect of that property while writing the will. Now a very interesting question, that whether you can make a will in respect of your spouse's property. The answer to this is the law does not recognize the spousal rights, so that you cannot make a will in respect of your spouse's property. In case of joint ownership as well, in spite of you making the entire payment of that particular property, you cannot make a will in respect of the joint ownership held by your wife or your spouse. Now before getting into the next important topic, in case if you have not liked or subscribed my channel, please do it, so that it will help me motivate to do more interesting videos on interesting topics. So now, next important question that everybody faces is that we have done the nomination in all our investments. So whether a nomination is important or a will is important. So in case if you have written a will, the provisions of Indian Succession Act or the succession laws overrides the nomination. So in case of a nomination, you will only be the custodian of the property until it goes to the legal heir. But the will is important, and it has the final say over nomination. Now let me give you a very simple and interesting example. A husband has a term insurance of ₹1 crore, and he has nominated his son to get the sum assured in case of his death. So in that case, his wife has no role to play in case of a nomination. But he has also written a will that all his movable and immovable property goes to his wife and not to his son. So in that case, what happens when there is a nomination? So in this case, the amount as soon as the father dies goes into son's account, but he will only be the custodian until the final legal heir is settled. So ultimately the amount that he has received should go to his mother, that is the wife of the testator, and not to the son. Now everybody has this question whether a will has to be registered. A will need not be registered, but it is very safe to get the will registered at the sub-registrar's office. And even a registered will can be contested in the court of law. It is no absolute, it can also be contested. But it is always safe to get the will registered because it has a more legal value than a will that is not registered. Because the person who writes the will has to come to the sub-registrar's office, and the various legal aspects are taken into effect when it is challenged in the court of law. Now what happens after the death of the testator or the person who has written the will? So an executor who has been named in the will or a legal heir can apply for a probate. A probate is nothing but the competent court will ask all the legal heirs of the deceased person that they have any objections to the will. In case if they have no objections to the will, the court will provide for a probate. A probate is nothing but a certified copy of the will, and that is a conclusive evidence that the will is very genuine. Now the last question is whether a will can be revoked. A will can be revoked at any time during the lifetime of a person, either by express revocation through the legal document or through implied revocation. So what is this implied revocation? So in case if a property has been written to a person on his will, but he disposes of the property during his lifetime, so that is an implied revocation. Also, if a vacant land is written on the will, but he constructs a building on that, that also is an implied revocation. So this is very important to know that the will can be revoked at any time during the lifetime of the person. So now, if a will is written, what happens? So all the painful litigations post death of a person in the family can be avoided. So it is very important that you write the will today itself so that there is no dispute in your family after your death. And if at all, most of the people write a will, so the judiciary will have no so much of a trouble when it comes to solving the family cases relating to the property. So friends, thank you very much for watching this video, and stay tuned for more interesting videos on personal finance, taxation and investments. Thank you for watching, and happy investing.